Welcome to Off Script Africa, where we have conversations with African professionals, creatives, and founders. My name is Amo, and I'm your host, and I am excited about my guest today. We have David Mujama. Hi, David.
Hi, Amo. How you doing? Love, we're all smiling. It's always a pleasure to be here.
It is. You really light up my world, to be honest.
Thank you for saying. You light up mine too, to be honest. Yes.
Yeah,
I'm really happy to be here.
I came in a little and then, your energy is so electric.
Really?
Yeah.
Really? Well, I'm like a little child. I'm really happy to be here.
You really are. And actually, the first time I saw David, I was going for a training at Les, right?
Yes.
And there was this gentleman who was floating around the room, energetic. And I was like, it's going to be a nice 2 days. And the entire time, it was such a beautiful
Is there any other way to lecture, though? Think about all the ones.
We
went to the same university. We went to the same university, different times, but yes.
It was giving Kikundu. It was giving energy and passion and intent and...
You know what his pass rate is?
Yeah?
86.
What's the other pass rate?
Well, other pass rates are much lower than that. I know convincing the pass rate is really, really low.
So does he pass us or he teaches?
No. It's you simply have to be either extremely dull, dramatically stupid, or an imbecile of epic proportions.
To fail his class. Actually, first of all, please introduce yourself before we get there.
Okay, so I'm David Mujama.
Yes.
I'm a lecturer at the Institute for Labor and Employment Studies. A lawyer by profession. Went to UB, as you've heard from the introduction. Got my LLM from South Africa. And I love the labor law space. A father of 3. 2 girls, 1 boy. I guess we'll get to know more about me as we go along.
And you are also originally from Kenya. How did you end up in Botswana?
Originally from Kenya. Came because my father teaches at UB, got a job here. So I got dragged here, come to school here.
Did you get dragged into teaching?
No. That came because the practice where I was at, I want to embarrass the partner, the firm had to close down. There was a whole investigation law society. You know how trust accounts are. Yes.
Sneaky business.
So I thought, okay, first I tried to go on my own.
Yeah.
And
to do in private practice?
Yes. That was tough. Because it's around the time when a lot of companies say, give business to Batswana.
Oh.
So to run a firm, most people don't know this, you need the big 3. You need a good bank that's giving you regular instructions.
Yes.
You need a good private entity that's giving you instructions. And then you need at least one individual client who's got a lot of money. One millionaire or billionaire. Once you have the big 3.
Okay.
You're smooth
wow,
sailing.
You sound like you could write a book about it.
No, because I failed at it. I can learn about how to fail at it.
We like those stories too. I think, isn't it a little bit daunting how you go to law school, you go to school, you get into the real world and you realize that you might be a terrible entrepreneur?
You and I both know they teach you accounting for lawyers.
Yeah.
But they don't teach you how to run a firm.
Absolutely.
They don't teach you how to run a trust account. They don't teach you that you need to have at least a secretary and a messenger, how to pay them first and the paper first and the ink in the printer first and the rent before you can even buy chappies for yourself. Yeah, so that goes off, and then I find myself at a private university.
Yeah.
And I started teaching. It was literally like doing trial without being asked questions from the judge. That's how I explain it. Lecturing is literally doing...
you're stunting.
Yes, it's doing an argued matter without having, your learned colleague trying to rubbish everything you've said, not having a judge saying, counsel, address me at this point. I've read your heads, but here, address me here. So it's a bit like that. The students are ignorant. They don't know any better. All they can do is say, no, but I've read the section. It doesn't say this. That's the worst that can happen.
They just drink from your cup of knowledge.
They're drinking from you. So it's pretty much like preparing heads, but you prepare heads, and then the audience is drinking from you.
Got it.
So that's you could make a wonderful lecturer.
I'll think about it.
You should.
Yeah, I'm just wondering how you remember. I guess class preparation. Or if you do something long enough, then
if you do something long enough, if you love it enough.
Yeah.
So, for example, the worst subject for me in UB was property law.
Yeah.
And close relative was the law of inheritance. So to this day, if you ask me anything about the law of succession, I remember only one Latin phrase, joinda re et verbis.
Okay.
Yeah, if you join word and thing in the will. That's all I remember.
You're also really good at languages. You know a lot of Latin phrases.
Yeah, we had to learn them during my
Yes,
time.
yes,
I'm revealing
yes.
my age now.
Yeah.
So during my time, you had to know re vindicatio, all of those. Don't say certiorari and don't say stare decisis. I say stare decisis. He said stare decisis. Don't mention those.
We shouldn't go into that territory.
Don't go there. So
if we hadn't done law, what would we have done?
I would have done engineering.
Oh.
Electrical, because I love connecting things and making sure they work.
Yeah.
I would have done accounting, because I love adding numbers.
I understand you also have a master's. What's your
Yes,
master's
LLM, human rights. Human rights. It was constitutional law and human rights, but in the second year, that's when I moved into labor law as part of the human rights thing. Because the other parts were, and I hope I can say this here, not palatable to me. So in South Africa, when I was doing my master's, there were lots of cases on the LGBTQIA plus community, and a lot of the human rights. There are classes of human rights. You've got first degree rights and second degree rights.
Yeah.
So dignity in South Africa was the big right.
But you listed your master's as one of your greatest achievements.
Oh yes. Oof. Look, I had to go through that self-doubt. Like, I don't agree with what I'm learning into this area, which was really, really tough. The coursework was tough. The small distinction we had to do was tough. And I'm really proud of what has come out today. And of course, as you know, you don't really need an LLM. So at the back of my mind, always, look, with LLB, you're there.
For your village people. Did you do it for your village people?
Yes, to some degree. And also, I felt, my dad's a lecturer.
Yeah.
To this day, he's saying, you can do your PhD.
You can be a doctor.
You can do a PhD. Yes. And once you get into the academic space, LLM is looked down upon you. Yes, you can't really research.
Yeah.
So LLM was a very good achievement for me, at least right there.
You're quite the people's person, I would presume. How would your colleagues, how would they talk about you?
Well, my colleagues, so let's start with, of course, the cleaners will say I'm really messy.
Okay.
So I'm the type of guy, from the time even when I was at a law firm, I would love to have the file here, the main judgment, which I'm going to rely on here, other judgments I'm researching on here, one of the papers from the file will be here.
And no one should touch anything.
Because I know everything is.
Yeah.
So the cleaners will tell you, hey, that guy, he's uwaka. Yeah, for the non-stoner speaking, that means someone who's really messy.
Yeah.
Yes. My professional colleagues will say he's just a happy guy.
Yeah, and your family and your kids?
Oh, my kids, I hope they love me. They'll say they don't like some things which I force them to do, like saying please and thank you. We just had a little fight yesterday because there's someone who helps to clean the house. Yeah. And they think she's supposed to do everything. And no, they have to take their plate to the kitchen. Yes.
Pay your keep.
So one of my kids, I think the soap was finished, so they unwrap a new bar of soap and they leave the paper there next to the washing machine. Who do they want to pick that up?
Who's going to pick that up? Yeah.
They need to.
Why does the employment law matter to you?
We have 24 hours in a day.
Yeah.
We spend 6 to 8 sleeping. Fewer for the insomniacs. We spend, if you follow the Employment Act, if you're in full-time employment, you're supposed to be at work 8 hours a day.
Yeah.
Some people are doing 45 hours a week. We do 40 hours a week. You and I both know our colleagues in private practice are doing more. Yeah. If you've got trial tomorrow or an argued matter tomorrow, you're probably sleeping at midnight. Absolutely. You spend a lot of your time at work. Yeah. You need to be comfortable at work. Yeah. You need to be safe at work. You need not to be bullied at work. You need no discrimination at work. You need to win at work. So my love for employment law is because it's part of my love for life. Employment is life. Those who are not employed, what are they looking for? They're looking for work.
Yeah.
Or they're self-employed. And even those who are self-employed in the informal sector need to be happy where they are. So I'm very interested, what does the law say about where we spend most of our times?
Because in winter, it's literally you leave when it's dark, you come back when it's dark.
Exactly.
Yeah.
Exactly. So should your boss shout at you? Should your supervisor overwork you? Should you
lose a spouse or have death?
Should you not be? There's an interesting case which has come to our desk today. My colleague is doing it, where someone at their workplace, they're being limited on their right to marry just because the demands of the workplace. Yeah, should your workplace affect who you marry?
Who you marry,
why you marry? Should your workplace affect the marriage relationship
So
itself?
what are the facts of this one?
No, well, I'm confidential. But brief facts, basically this person is employed somewhere and the employer said, no, you can't marry because of work demands.
Oh, there's no time?
What do you mean?
There's no time to do the wedding or to take time off or...
No time to do off, and your marriage to this person is going to affect the image of our establishment.
You know, actually, you're making me think of something. I was having a conversation with this lady, and she was saying how when you go for a job interview and you're a man and you're wearing a ring...
Yes.
Oh, actually, I had a friend who wasn't hired because... And it wasn't a law firm, but she wasn't hired because she had a husband and children. Right, so I was talking to her about this. I was telling her about the lady that I'd met and how when you're a man and you're married, there's an assumption that you have a wife at home and she's taking care of business. When you're a woman, it means you're going to be taking time off. All the kids are going to be sick. So there are those inequalities.
At the Institute for Labor, where I am, I've got a labor economist, wonderful guy. Shout out to Abel. And little research has shown when a single mother is in the interview room. The reason why we've got a pay gap, the woman who's in the interview room, when she's asked the important question, how much do you expect to be paid? The reason why we have a pay gap in Botswana is because, number one, a lot of women in the workforce are single moms. And when they're in the interview room, they're asking for lower salaries to compete against the other person, to make sure they get the job. Yes, they already know from the advert that it says between, there's an advert magistrate. So if a single woman comes in, they already know what the advert is saying. They always go for the lower amount. Let's say
lower range.
Yes, if it says per annum, the salary will be 360 to 400.
They'll always ask for the lowest.
They'll ask for the 360. They won't ask for the 400.
So this new labor law is promising us a lot of things.
Section 18, subsection 5 says that people will be paid the same, should be paid the same amount if they're doing the same or similar task.
It's new.
So there should be no discrimination on the basis of gender, sexual orientation. That's another research which we're doing at the Institute. It's new research. We want to know of those people who have come out in the open since the Mutsidiemang case, when you could come out, are people from the LGBTQ community being paid the same as heterosexuals. And the hypothesis already is that there is a pay gap. Took me back.
It feels fair though, because I think even with other races, they normally pay their counterparts better than...
Well, with other races, unfortunately, we've got a lot of foreign direct investors here in Botswana. So, of course, because they're the investors, they're paying themselves more.
But for equal work, we should all get paid.
Equal work, equal pay.
Okay, this feels very ideal. We're going to talk about the Employment Act and
that's Section 18, subsection 5. Everyone should look at it. It's an easy section. No one should get a lawyer to read it. They should go and read it for themselves. I'm excited about that provision.
Section 18. Wasn't the penal code at Section 18?
No, talk about the...
No, I know, but I'm just remembering that there's a popular Section 18
now,
penal code.
Sections in penal code, why that's ringing in your bell? Why that's ringing a bell in your head? Sorry, ringing in your bell. From Section 4 up to Section 20 is the preliminary aspects of criminal law. So your age, your age of when
consent.
you can be found liable.
Oh, okay.
You know,
Okay.
when compulsion, all of that is between that.
Okay,
So that's why Section 18 is going ding, ding, ding.
Okay.
Yeah, I can't tell what it says.
Linda, I'll remember.
But it's an important section. But I just know from Section 3 up to 20, those are the fun.
Before we get into the Act,
Yes.
it's promising a lot, right? Do you think that would be able to implement? Do you think the changes are?
Disclaimer: I'm an optimist.
Okay, so the glass is half full.
There are some parts which we are already implementing,
Okay.
and already there's a change.
Yeah.
What part is that? Disciplinary hearings. So, for business owners, which camera is important? That one?
This
one? Okay.
one. That's
So,
your
for
camera.
business owners, if you want to read any section, you want to go straight to section 163. In fact, read section 162 up to 168. But 163 talks about disciplinary hearings.
Yeah.
So already, what was happening before 1995? Kana Batswana were being
Fired.
like roaches.
I think people actually
Ja,
still
come on,
think,
Vele.
but people actually still think that's how you fire people. That you can just say, "I'm firing
You're fired,
you."
yes.
That's it. Like
Well,
no
especially
hearing.
maids,
Yes.
badisa.
Yeah.
If you own a semausu, that girl who you have employed for your semausu, most other people are being fired like that.
Yeah.
In the retail space, the small shops, people are just being fired like that. You're fired.
Yeah.
Not all of us are Donald Trump. With all respect to the orange-haired guy. So in that space, I'm seeing a lot of implementation, but this is because of years and years of judgments from the industrial court
Yeah.
setting up that there must be a hearing.
Yeah.
That you must give notice before the hearing. There's a way the notice needs to be structured,
Yeah.
so they need to read the act.
Yeah.
You must allow for questioning. You must allow for witnesses and all of that.
Allow them
So
to access the
yes.
information.
that part is being implemented.
Yeah.
When you go somewhere down the line, there is retrenchment. So
Okay, so change number one, maybe we'll elaborate a little bit.
yes, change number
One
one
is that
the Employment Act
has now codified.
it's codified disciplinary hearings.
Yeah.
Not just
So,
disciplinary hearings, incapacity hearings.
okay.
So if someone is, let's say, injured,
Unwell or
well, it says physical or mental incapacity, which is really, really important. So mental health is now in the act.
Okay.
That should be implemented because we all go through a lot.
yeah,
go
we
through a
do.
lot, you know,
We're on a floating rock.
we are. Look at the divorce rate.
Yeah.
The divorce
Actually
rate is
watched a
telling you
podcast
that
about
as,
that.
as a society, we are struggling. Okay, people are getting into marriage. They don't know what the marriage contract really means. People think it's the wedding. The wedding is just the day one.
The implementation of the Employment Act.
Yes. So disciplinary is already being implemented.
Yes.
Some parts which are going to be interesting to see if they're going to be implemented. Employers now have a duty to meet with their employees to discuss about sexual harassment and bullying at the workplace. That's going to be interesting to see how that's going to be implemented.
Okay.
Nowhere does it say that labor inspectors are going to go and see if employers do that, but they should. The only catch that if you don't do that, if your employee claims that they were sexually harassed or they were bullied at work or there was violence at work, and you can't show that you did everything to make it safe,
Yeah.
you're going to be in trouble.
That would include policies, training.
Yes. So I'd love to see the new retrenchment provision, section 165. That's going to be interesting to implement.
Okay.
So the old section 25 said if you want to retrench, you give notice to employees, give notice to the Commission of Labor, retrench. Now you need to have a consultative meeting with your employees. Now you've got to rope in the trade unions. Looks good on paper. I'd love to see how that's going to be implemented. So there's some parts which are easily implementable because they're already being implemented. Some parts are totally new.
But we can agree that it's a step in the right direction.
Yes,
Yeah.
yes, it really is. Look, it's a better law. I'm happy for it. There is this belief that it's going to chase away investors. I don't think so. I think it's going to chase away the exploitative investors.
Yeah.
The ones who want to come here and mistreat Batswana and have it easy and just take away profit and go. The ones who already have good labor laws in their country are going to be excited to come here because it'll be something familiar.
Okay.
So we should be attracting the correct type of investor,
absolutely.
not the wrong one.
Okay. Yeah. So how has the definition of a worker changed?
There we go. Now so under the old employment, just had an employee, someone who has signed an employment contract.
Okay.
Worker now includes those in the informal sector, casual laborers, those on fixed-term contracts, those who are on permanent contracts. So a worker encompasses anyone who's in the working sphere. And then get this, a worker also includes someone who's applying for a job.
Oh, yes. So even at recruitment...
At recruitment stage...
There's a protection.
There's a protection. If you are bullied, if someone says, I'll give you a job... Is this still PG-18? I'll give you a job through transmission.
Yes.
Yes. Physical transmission. You've got a claim at that stage. If you're discriminated on the basis of race, political opinion, gender, you've got that protection. And then you should look at section 151, my favorite area, 151 to 157. You're not allowed to discriminate.
Yes, I was going to go into discrimination, harassment, and fair treatment.
Yeah, no, I'm coming there.
Oh, you're coming there.
This is something extra.
It's different.
We didn't say this even last time, so it's good we're re-recording.
Okay.
You're not supposed to discriminate between full-time employees and those who are fixed-term employees. You're not supposed to discriminate between your part-time employees. So in terms of training, if you're going to give training at work
I was going to ask
to your fixed-term, you're supposed to give it to your part-time employees. How you're paid, the rate at which you pay. The rate at which you pay your fixed-term employees is the same rate you should use for your part-time employees. That's what the law is saying. That's a whole new change. It's
so you don't have the liberty to do as you please.
Yeah,
and mistreat a temporary employee.
What some companies would do is that those who are permanent and pensionable would get the training, and then their salaries would be on a different rate. Then there would be a part-time scale, which would be horrendous, maybe 200 per hour for trainers, for example, or lecturers. So now, whatever you're paying your full-time guys, that's what you must pay your part-time employees. So it's really, really fantastic.
Okay. Really and then fantastic. What about temporary employees? I know a company that had a temporary employee for 5 years. Okay,
so now we have to define what you mean by a temporary employee.
Okay.
So full-time employees, those are permanent and pensionable, let's put that on one side.
Yes.
Then there are those who are full-time who are on fixed-term contracts, maybe 5 or 3 year contracts.
And they are eligible for gratuity.
We don't call those temporary employees.
Yes.
Then you've got what we call part-time employees. A part-time employee under the Act is anybody who's working less hours than these two.
Yes.
That's the definition.
And then temporary employees, people who are hired at 3. It doesn't exist anymore.
Then I've got what we call casual laborers. So people who are on 3-month contracts, there's a clause in the Act which says if you keep them for 12 months, there's a presumption of permanent employment, unless you can justify why.
So in that scenario where there was a temporary employee who's been 3 months for the past 5 years, they would be presumed to
once from 1st of September, if you keep them on like that until 31st of August 2027, you've got a permanent employee.
So does it mean that we've also done away with fixed-term contracts?
Again, unless you can justify why. So for example, you'd say he's a foreign national.
Okay.
That'd be a good justification. Or you can say the task is only for 3 years. Okay.
But normally CEOs and very high-level management are on contract.
Yes, so that would be your justification. They've been brought in. Most CEOs come in to steer a company in a particular direction. BMC, for example, the time it was going down, the CEO came to make it a going concern. Right now, many parastatals, you've heard what the president has said. He wants to make these parastatals a going concern and profitable by a particular period. So CEOs are being brought to do that specific task.
Yeah.
That's a justification for having that short-term. But without the justification, there'll be the presumption of permanent employment.
Okay, but would it still force the employer to pay pension? Because some people prefer gratuity. And
so now you'd have to opt out. That hasn't changed. I hope with later versions of the Act, there are going to be some amendments, by the way.
Oh, really? What are we looking at?
There are already problems.
There are already problems.
One which I think we can say on this podcast without getting into any trouble, the Employment and Labor Relations Act has this clause in Section 2. It says the industrial court shall continue as before in terms of the Industrial Court Act.
Mm-hmm.
There is no Industrial Court Act.
No, there isn't.
It's the Trade Disputes Act. They have repealed, there's a notice, there's an act already for repealing the Trade Disputes Act.
Yeah.
There's talk of making the industrial court a division of the High Court.
Yeah.
So just on that alone, we're going to have an amendment of Section 2 of the Employment and Labor Relations Act, just on that point alone.
Actually, you're reminding me. I hope that it's somewhere down in my questions, but
yes.
With the Trade Disputes Act, so before you had 30 days to approach that. If you had been unfairly dismissed,
yes,
you had 30 days
That's
to...
Section 6, Section 7 of the Trade Disputes Act.
You're so impressive. You know, do you dream these sections?
I don't dream these sections. It's what I do.
Okay.
It's what I do for
Fair
living.
enough, but it's impressive.
It's what I do. Look, if you're a divorce lawyer, you would know Section 14 and 15.
Okay, you're fair enough. Yes. Okay. So before it was 30 days.
30 days. It's
and
now
there's some, it's 90 days now.
90 days now.
Yeah, there's some industrial
283.
court judges who would be like, nope, 30 days is 30 days. But so why was there the change to 90 days?
The change is because we spoke about implementation. One of the biggest problems at the District Labour Office is backlogs.
Yeah.
And if you look at the backlog of cases, it's condonation applications. So under the old law, what you do if you've brought your claim up to 30 days, you do a letter explaining two things. A, why were you late? And B, the strength of your case. And then the mediator would have to do that, make a ruling, and then start your case. I'm from Maun. The Maun office is woefully thin.
Yeah.
We need more mediators there.
No, absolutely.
Yes.
And I'm sure even in the industrial court there's thin.
Yeah, it's a mobile court actually, so it's not a permanent court.
Oh, yeah.
So we do need more staff and all of that. That's going to happen. Okay,
let's talk about the amendments as they relate to leave.
Yes. Oh, yeah. Like that, my face lights up again. So we've got a number of leave provisions. Which
we were not there before.
Okay, now before, what was there? There was annual leave, there was maternity leave.
Okay.
What are the new ones? There's family responsibility leave. There is trade union leave, there is paternity leave, and for the LGBTQs and those who can't have children, there's adoption leave. Adoption leave, but only if you're adopting a kid under 2.
Okay.
So you're adopting a kid under 2, you have to follow what the sections say. You have to tell your employer when your court date is coming, blah, blah, blah. And then you've got to choose, So there are 2 types of people who can take advantage of that. It's heterosexual couples who've been trying to have a child, but haven't been able to. I love the trying part. I'll still keep trying. But I can get a child. And then you've got your non-heterosexual couples who obviously for biological reasons can't have a child. You've got to tell your employer who's going to take maternity leave, who's going to take parental leave.
Okay.
So you have that discussion before. Family responsibility leave.
So adoption leave would be the same term as maternity leave?
Whoever is going to be the mother,
not
the same term, it's shorter. So maternity leave has now increased from 12 weeks to 14 weeks.
Okay, change number 1.
Yes. Yeah. We'll come to maternity because the number of changes there.
Okay.
Adoption is only 10 weeks.
Okay.
Yes. Not 14.
But it wasn't there before, so we're grateful.
Wasn't there before. It's sweet. And strictly speaking, you're not healing.
Yeah,
you're
so it's different.
Bonding. It's different. Well, I've never given birth before.
I wouldn't have guessed that.
Well, I'm told it is an experience and a half. Yeah, so 14 weeks makes sense for those who have done natural birth or cesarean section. Okay. Cesarean is an operation. You've got an epidural in your spinal cord. You do need some time to heal.
Yeah, absolutely. Yeah. So maternity leave, we have 12 to 14 weeks. What else do we have under maternity leave?
Then under the Old Employment Act, you could only claim your salary from one employer. If you've got more than one employer. Most of us have a side hustle. So if you're a woman and you had 2 employers, you could only claim your maternity allowance from, they call it maternity allowance, not even salary, from 1. Now you can claim from all of them.
Yes. Okay.
Change number 2. Change number 3, which we're really happy about. It's a step in the right direction. We're not there yet, but Gavi
Yeah.
did something. So it used to be 50%. So if you're on maternity leave, you'll be getting 50% of your salary.
Yeah.
What would happen? Many women would try to come back to work as fast as possible. So they're not getting 50, they're getting 100.
Yeah.
And,
I remember I did a case actually
yes.
where the lady had saved up her leave days so that one of the months of the 3 months
Yes.
is annual leave, because
She went
when you
full.
when you looked at her salary, her half of her salary was
Peanuts.
Yeah, it was peanuts, absolutely, but it was also loans and medical aid and stuff. So it would mean that for those 3 months she's not getting an income at all. Yeah, so
Ooh.
of course I think when she realized they didn't credit her leave days, she just, kept quiet, and then a year later they realized and they fired her, and the court was like, no.
That's another important change. So firing while someone is on maternity leave, there are provisions on that. You can't do that on the new act. You can't do that. So that's very exciting.
And you can't be fired because you're pregnant.
You can't be fired because you're pregnant, and they can't give you notice of termination while you're in your last trimester. Yes.
That's nice.
Doesn't mean that women who are expecting are not
Cannot
naughty.
leave or can leave. They can leave.
Some can be naughty. Some can do misconduct. Some do stretch the limits of work performance.
Yeah.
So there's still some disciplinary issues there. You just can't give them the notice to terminate while they're in their last trimester. And
You have to wait.
And you still have to pay them their maternity allowance. It's now moved from 50 to 70%.
Okay.
Yeah. So if you're interested in all of that,
that's very-
section 222, go and read it. All women need to look at it.
And you also do training at the Labour Institute.
Yes, we do. We go deeper. We're rushing through this.
Yes.
Come to the Labour
Yeah.
Institute. We'll go through it slowly, section by section. You can come with your policy and we tell you change here, stuff like that.
Okay.
Then paternity leave is a big one. Yes, I
New
love it.
also?
Very, very new. It wasn't in the Employment Act. Of course, in the public service, those who are watching this, they'll say, no, there was paternity leave in Botswana. Yes, companies were having policies which were better than the Employment Act. So your top private sector companies would have paternity leave, of course. Because it wasn't in the law, people weren't enjoying paternity leave. Now men can. It's not a lot of days, but if your spouse or mother of your child, develops complications because of childbirth, you can get the balance of the maternity leave.
That's also new.
That's very, very new. That's very, very new.
Okay.
Family responsibility leave, that's another very new one. And we are hoping it's going to improve productivity. Because one thing which most employers hate is, my child is sick. I need to go and collect the report card from school. All of these small little requests for leaving the house. So there's something called family responsibility leave to cover death and serious illness.
I was going to ask. It was called compassionate leave in some policies.
Yeah, that's in some places called compassionate leave. Now in the Act, it's family responsibility, but it's limited to death and serious illness in the family.
Okay.
Only.
Okay.
If you're going to collect report cards, if there's a PTA meeting, whatever, those excuses, you'll still have to get compassionate leave. Yes.
Oh, sick leave. Oh, are we done with?
There's also sick leave hasn't changed. Sick leave is also there. The big change on sick leave is that there's your days for being sick, and then there's being in hospital.
Ooh, okay.
Extra.
Okay, so it would be is it still 18
20.
days? 20. It was 18 before.
Yes, so 20 sick, 20 in hospital.
Yeah.
But look, there's a lot of complaint. People are going to... How many people are hospitalized, really?
Yeah, no, absolutely.
Really, it's a small percentage.
And most times employers would just fire you if you... If you're forced to go to hospital, they'll incapacitate you.
They'll incapacitate you.
They'll put you on unpaid leave.
Yeah, but now there's you don't just incapacitate someone, there's incapacity hearing. You're supposed to investigate the extent of incapacity. You're supposed to get a medical certificate saying the person is incapable of work. You're supposed to find alternative to firing. So if you can adapt,
give them different
if you
work.
give them a different work, for example, someone like me, make me a receptionist
Yeah.
Make me the guy who stirs coffee, whatever.
Yeah.
Give me something else.
Also because sometimes incapacity is from injuries in the workplace.
Yes.
So you have to make reasonable accommodation.
There we go. There we go. So the act covers that.
Okay.
Have we left out any leave?
Sick, annual, maternity.
Trade union leave.
Trade union leave, yeah.
Now there's trade union leave. Employers, once you have recognized a trade union, is supposed to give leave to either representatives of the trade union.
Okay.
And if you have any leaders of the trade union in your workplace, you're supposed to also give them a reasonable leave. Those days are not specified. You negotiate with the union.
Okay.
So that's really, really new. It's very exciting.
Yeah, it's very, very exciting.
We're now very much aligned to most of the Western world.
To the ILO.
And ILO standards. And
ILO
your Singapore.
International Labour Organization.
Yeah. You want to talk about ILO? 30 seconds, do we have
Okay,
time?
yeah, let's do
So
ILO.
it's the oldest wing of the UN.
Okay.
Yeah, so if you Google history of ILO, World War I happens. People don't know this, but behind World War I and World War II were big labor issues. So World War I comes at the turn of the Industrial Revolution. There was a lot of questions. It's not the only issue, but a lot of course, Germany was trying to control Europe, but it was about labor.
Okay.
And labor rights. So the League of Nations becomes UN, and the first thing UN does is said we need to have an international labor organization where countries come, governments come, and federations of trade unions come, and we discuss international labor standards. And then countries can choose to adopt conventions, and they have core conventions, they have fundamental conventions, just the basic minimum, and so now we're reaching.
I can see you in the ILO. I can see it.
I receive
somewhere.
Lay hands on me, Amo. Lay hands on me. Pray for me. Hallelujah. There we go.
Okay. So child labor, anything there?
Oh yeah. So
all of them excite you.
I'm really, really happy. It's a modern act. It's a modern act. It's a step in the right direction. It places us with other countries. Really proud of Botswana. I'm really, really proud of it. I really, really am.
I think we're proud too.
So the Employment Act, the old one, which is being repealed now, defined a child as someone who is below 14. Big problem. Children's Act, if you look at the UN Convention on Rights of the Child, a child is someone who's below 18.
Okay.
So how our new act has coined it is that you cannot employ someone who's below 15. We've raised it from 14 to 15, a big change, number one. Number two, between the ages of 15 and 18, you're what we call an apprentice. And you can only do light work. And you cannot work at night. What is light work? By the act, go right to the last page, right at the back. Just turn it upside down, open there, there's Schedule 2, you'll see a list of light work jobs. It's pretty simple, things which don't break backs, things which shouldn't affect the learning of the child. And what I love about our act, the way it's structured, Section 6, 7, and 8, talk about child labor. We've accommodated business owners who want to train their children on the job.
Yeah.
We've accommodated tribes. Yes. There are tribes in Botswana, we won't mention the tribes so we don't step on any toes, who you'll see the kids carrying sweets and stuff. They use their kids as part of the informal sector. We've accommodated those, and then we've accommodated kids who maybe have dropped out from Form 3 and they want to learn some skill or, how to fend for themselves. So it's a modern act in that way. What we have removed is the exploitation of children. Yeah, we don't make Nike shoes here in Botswana using infants. We don't do that here.
Yeah.
I'm really, really proud of the act.
Okay. So let's go back to disciplinary hearings. And can you just fire someone?
No, here in Botswana.
If you feel like it just...
We don't do that here. We don't do that here. If someone has committed misconduct, first and foremost...
Wait, but wasn't there a section in the Employment Act about how you can give someone notice?
No, there wasn't.
Okay.
There was the famous Section 26 talking about serious misconduct. So serious misconduct was defined.
And there was a list.
And there was a whole list, late coming, absenteeism, willful disobedience, blah, 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 off the top of my head.
Yeah.
Now, in fact, we've defined what it means to terminate a contract under the new act. So if you're an employer, you want to rush to section 162 and educate yourself on the 5 different ways in which you can terminate a contract. I'll give a teaser. If you are employing people and you give them a reasonable expectation of renewal, so you keep on renewing. I remember you spoke about those people on 3-month contracts, and you keep on renewing, whether or not they meet their target or not. So you are just keeping them a 3-month contract because it works for you financially, without thinking that, how are they going to plan their future and stuff. So 3-month contract like that. And then one day you decide someone's eyebrows are too big, someone's boobs are too small, whatever it is. Someone's breath is too garlicky, whatever it is, and you decide I'm not renewing. And many business owners were doing that. They'll say, don't renew that contract.
Yeah.
That's now termination of employment. And you cannot terminate without giving notice. You can't terminate without having a valid reason, a fair and valid reason. And the way you reach that fair and valid reason is to have
without giving notice?
You have to give notice that the hearing is coming.
Oh, okay.
Yes.
Not that you're terminating.
No. Notice of the hearing. Okay. And in that hearing, you need to have a fair and valid reason.
Yeah. And
tell them what they have done wrong. Whatever you tell them has gone wrong should have existed at the time the act was committed. So don't create offenses out of your head. Don't say the employee didn't stand up and that was insubordination. When your policy doesn't say that employees will stand up when you come in, don't do that. Yeah. Don't create dress codes. Now that there's this thing about sexual harassment, don't create dress codes and then implement when it didn't exist before. So your policy should have identified the behavior before it happens. Make sure your notice explains what they've done wrong in detail. If you come to the institute, we explain how to draft those up. Make sure you've given the employee their rights at the hearing, their rights to be represented, to call witnesses. Don't ambush the employees. Give your employees a chance to mitigate. Give them a chance to appeal, and they should know all of these rights before the hearing. If you've met that threshold, then of course don't jump for firing. Don't fire where, by the way, poor work performance is no longer misconduct per se. There is a process. If you've got someone who's not performing at work, there's actually a process in the act on how to address that.
Oh, maybe we can talk about probation then.
Oh, yeah. Probation also. So, yes. So whenever I teach about that, I always turn back to the side on probation. Also, how you treat employees on probation, that's changed.
Yeah.
So under the old act, if you have someone on probation and you don't like their eyebrows, you don't like the size of their elbows, whatever it is, all you have to do is give 14 days notice. That's it. You could have a good reason, you could have a bad reason, you could have no reason. The act said for no reason at all.
But I'm realizing that when you're an attorney, you really see so much. I remember there was a gentleman who worked
somewhere.
I'm just wondering how much detail to give, right? But
make it generic.
Yes, okay, yeah. So person A works as a supervisor in an establishment, right?
Yes.
And one time somebody gets fired and they write to the head office and say, oh, this person was sexually harassing me. The reason he didn't confirm me is because I refused to sleep with him, right? And he's just the sexual harasser. Then we do investigations with different branches, and of course, the pattern is there, right? So the groping and the sexual favors, and so what he would do is that he would wait until the last stage to tell you that he's not confirming you.
Oh,
yeah. So he would hire you for your probation is 6 months. He will extend it to 12 months, and even on that last day,
to give him the chance to assist himself to you.
Yeah, I think also just the extension of the probation would be not because of your performance or anything, just holding you at ransom.
Oh my goodness.
Yeah, so
I hate creeps like that. Now the reason why I do what I do is to eradicate creeps like that. I don't like. I've never defended a rapist, not ever.
Yeah.
And I don't defend creeps like that. Yeah, if you need romantic assistance, There are licensed premises where you can go.
Romantic assistance.
Yes, go and buy that lady a drink.
Yeah.
Put in your application politely, and wait for a response. If she says no, there are 4 billion women. Is it 4 or 3 billion on this planet? If
Plus
she says
or minus.
no, yes, go to the next one. One of them will assist you at your point of need. Please, there's no need to rape. There's no need to harass at the workplace. I really, really hate sexual harassment.
No, it's terrible.
I hate it.
So we haven't gotten there, actually. We haven't, right? Yeah, we haven't. Oh, yeah, for probation. For probation, yeah,
you can no longer just fire for no reason. So, 3 changes. Number 1, probation is no longer 12 months. It's 6. Must be in writing. Second change. If the employee doesn't meet the standards that you want for the workplace, you have to inform them. And then there's a whole list given there. You're supposed to give them counseling, training, mediation, arm around their shoulder.
Yeah.
Yes. Help them to get the standard that you want. Show them how your business works. Only then, if they have not met the standard and you've had a hearing with them, can you dismiss. No longer no reason. No. That's old law.
And that was the advice you'd get, that don't give any reason so you don't have to explain anything.
Yes.
Because if you give a reason,
now
then
you have to explain. Yes.
Now you have to have a reason.
Now you have to show that the reason is that they're not meeting the required standard. That is the reason. Anything else is discrimination. It's illegal. You'll get into trouble. So if you're not confirming, and if you just keep quiet, also that's change number 3. If you just keep quiet, the act says it will be deemed to be confirmed.
I think that's also in the old act.
Yes.
Yeah, that you become an employee.
You can't play if they keep quiet.
Yeah.
But now.
Okay.
Now you really need to let people know what the standard should be. I sense you liked the old act.
No, I didn't. I did not. I love the new act.
And, I could give a whole other podcast on what I hated about the old act.
Yes, and we can trash it. We can trash it another time. Yeah. Okay, so we talked about poor performance.
Poor performance now, similar to probation.
Yeah.
You have to do it. So it's no longer a notice saying, I'm calling you for a disciplinary hearing, poor performance. No. You give notice and say, employee, you're not meeting the standard. This is your job description. This is how I want you to work. And then you have to have a meeting, not a hearing.
But how was it before?
Poor performance was a form of misconduct.
Yes, it was in the list.
Yes, it was a form of misconduct. Now, there's this whole paradigm shift. Now the employer has a duty to find out, but why is my employee not performing? Is the chair not fine? Do they have the tools of work? So you have to have a meeting, not a hearing. And there has to be a representative or a trade union shop steward there to assist him to bring the employee to the required standard.
Okay.
So it's a bit like pupillage, This you're supposed to have someone senior above you telling you when do you say my lord, when do you say so you do that only then after the meeting. If the employee doesn't meet that standard, now you can dismiss.
I really like this new act because it really outlines things. A lot of the old act was having to read case law and having to.
If you are not in the legal space, yes, because even getting those judgments,
it's difficult.
It was difficult. So if you are not in the legal space, as an HR personnel, as an employer, I wonder how you are going to know what the law says. I really wonder.
Yeah. Okay.
So this one has really codified a lot of judgments, and put it down into place.
Incapacity?
Incapacity, now, there was an old judgment, Elephant Black Safari's case. It's the equivalent of Pirignani.
So it also wasn't codified?
Also wasn't codified. Yeah. So now, if there's incapacity, 3 steps. 1, investigate the extent of incapacity. So don't just say the employee can't do the work. What can they do? What can they not do? Step 2, you need a medical certificate. And the doctor should agree with your investigation of incapacity. So the doctor should say, yes, this employee cannot do X, Y, Z. Okay? And by implication, then he can do A, B, C.
Yeah.
That should be there. Then must have a hearing. Sit down with the employee, offer alternate employment. It might come at a different pay, but you must give that offer. Okay, and try and find means to adapt the employment to suit whether it is mental incapacity or physical incapacity. Okay, if it's mental, of course, maybe the guy just needs counseling. I'm thinking of a case where there was this guy, in his own words, he'd say, Musadi, one duba siboroto. Yes, in his own words. Okay, so in English, for those of us, you can laugh, okay. So in Botswana, we love, boroto is bread.
Yes.
We love dumplings also.
Yes.
So to make the dough, you have to punch it like that. Yes, exactly what she's doing. So you say, my wife beats me as if she's making dough. That would break a man. That would really break a man. So counseling, see what can be done about that.
Also, he wasn't performing well at work because of the
instead of
issues
becoming
at
an
home.
alcoholic, the question was, why are you drinking the way you're drinking? And the answer is that my woman makes dough with me, all the time.
Oh, okay.
So now we're asking employers to be a little bit more compassionate. Try and find out what's wrong with him. Let the doctor say what he can't do.
So that entire list of misconduct is gone. So what happens if someone does come to work drunk?
No, coming to work drunk is still there. But mental incapacity is something else. So
you can't always just jump to misconduct.
No, don't just jump to misconduct. You have to investigate the extent of incapacity. So alcoholism at work can be a symptom of mental incapacity. What's wrong? Not all people are
okay.
Yes, So let's have more compassion. That's what the spirit of the act is, compassion at the workplace. That's where we are.
I like that. And you can really say this because you were part of the...
And I hope you are practicing that at your workplace.
Yes.
I
absolutely.
hope because you've gone through, I hope you're preaching this same gospel.
Yes, absolutely. And that's why we're here, because we're preaching this gospel.
Amen.
Yes.
Amen. I'll have a sip to that. Please go and look for the following words in section 2. So section 2 is the interpretations clause. You've got a dictionary of words there. Go and look for the word intimidate. Go and look for the phrase gender-based violence and harassment. Go and look for the phrase harassment by itself. Go and look for sexual harassment. And you will see or you can come for the training at the Institute for Labor and Employment Studies.
All the better.
But you will see a toxic work environment is one which is unsafe, is one where the policies, is one where the culture of the workplace creates an environment where the employee, so it's the focus on how the employee feels. The employee feels unsafe, the employee feels threatened, the employee, other symptoms which the act doesn't say. You will find you suffer psychological and physiological symptoms. So you might be at a workplace and you find on Friday, you're all bubbly and fine.
On Sunday,
and this is how I was taught. So true.
Yeah,
there's a pain. It's like a pain which can I reach? Oh, I need to lose weight somewhere here. There we go on the back.
Yeah.
This book again. I'll borrow this book so I can.
So that you can.
Yes. There we go. Yeah. So there's a pain which comes on your shoulders. Honestly speaking.
No, absolutely. I think we've been in a toxic work environment.
If you've been in a toxic work environment, that happens. If you start getting scared, if you start getting physically ill, some people get a flu which is never going away.
I'm getting so triggered.
Oh, I'm so sorry. Do you want me to hold your hand? There we go. I'm so sorry. Cry it out. We're laughing.
This is what we're doing at therapy, you see?
I love your therapist.
Yes,
is she female?
Yes, she is.
Okay. Is she fun like you?
Yes.
I might consider therapy.
Okay.
I just might. So that's a toxic work environment. Now, when we talk about harassment per se, the Act covers all forms, and there are two examples I want to highlight for this podcast, which happens in Botswana.
Yeah.
There's something called mobbing. What's mobbing? Mobbing is where the workplace is toxic in the sense that there's two or more groups which have been formed. It could be over gender lines, could be over tribal lines. I won't mention where this workplace is, but some people will pick it up. So there's one particular workplace where you'll find people who have studied in South Africa, and those who went to UB have formed two groups or two camps. So the ones who are sponsored by government to go to South Africa, those who got A. I don't know what it was for your year, how it was. the coast of Africa. And then Rona by A and then B would go to UB. Yes.
Okay.
Now, the workplace, you find those ones, I think they're so much better.
Yeah.
And we would, speak in Setswana.
Yeah.
That's mobbing. And if one group asserts control over another one at the workplace, this happens. Sometimes it happens over tribal lines. Okay, so in Botswana, how many tribes do you have in Botswana? Lots.
I don't know.
And then the problem is that some of the tribes are Tswana-speaking tribes.
Yeah.
Then we've got tribes which have got their own language. So you'll find that some workplaces, those that have their own language, be it just Setswana itself, or Herero, or Kalanga, or Simbukushu.
Oh, Kalanga. My mom is Kalanga, so I can say this. But Kalangas have, they have a solidarity.
Well,
and they will speak their language.
I'm from Maun. Mbukushus love to speak their language.
Yes.
Hereros love to speak their language. There's one industry where bullying happens, unfortunately. Sorry, guys, I know you're going to watch
absolutely.
this. Our legal industry.
Yeah.
There are some partners who,
throw you under the bus.
Throw under the bus, shout at you, and I kind of get it because they're paying from their pocket.
Yeah.
Them teaching you is from their pocket. I kind of get the temptation why they would want to bully. But I really believe we can make better attorneys in Botswana by loving criticism and not calling someone stupid.
You did say that on your first day at court, you walked into a trial.
Yes. I was told, no, go and continue. I didn't know what I was doing.
You didn't even know how to introduce yourself.
Don't know how to introduce yourself. I'm not the only one. There's so many other people.
Yeah, no, absolutely. Yeah.
You don't know how to address the court. You ask a question, the magistrate pops in. No, you're leading the witness. Can you ask it a different way? Counsel, no. Don't do that. So you'll be fumbling all the way.
You actually reminded me of a colleague of mine, a friend of mine. So she had... she'd lost she's from Zambia. She'd lost her uncle in a car accident, and she had to go and identify the body in Maung, had the body repatriated, and on Monday her boss was like, you have a court to maintain Lobatse. So she got like 2-3 days off.
Now those who probably don't understand, those days the high court they still have court in Lobatse, but even the drive to Lobatse, I'm thinking about it with after suffering a loss in the family.
So at least compassionate leave now would cover something like that, right?
Yeah, family responsibility.
Family responsibility leave.
Yes, compassionate leave, that's something in the private sector.
Yeah, okay.
That would cover that. So bullying is impossible deadlines, destructive criticism at the workplace, okay? The Act also covers violence at the workplace. Now, we think there is no violence at the work. You'll be surprised how much violence there is. Actual physical violence.
Physical violence.
Yes, actual physical violence is there. Actual mental violence happens at the workplace, which is another form of bullying. Those can create a toxic work environment. This is no longer allowed at the workplace.
Yeah.
So, please, if you're watching this podcast, go straight to Section 17 of the Act. It says an employer will do everything that they can within their power to in consultation with the employees, to eradicate bullying, violence, harassment, toxicity at the work. There must be a safe working environment.
So there's an onus on the employer to be proactive.
By the way, so if I say that I'm bullied or harassed, there is a reverse onus. Once I make the complaint, the employer must show.
It's not a he who alleges must prove.
Now the employer must show that they did everything they can to make the workplace safe.
Ooh.
Otherwise, I want to draft.
I think we're going to go into that. We're going to go into the penalties.
I'm waiting to draft that summons. First defendant, I put that company there, PTY Limited. Yes, and right at the
What
bottom.
steps did you take to ensure that there's a
they
safe
took
environment?
no steps. Yes,
there were no policies. There was no training.
Yes. Nothing happened. Then I say, wherefore, the plaintiff claims for 1 million pula.
So it would
severally.
It would be sort of a damages claim.
Yes. Oh, there's two things now. So the act allows for damages, and then there's also a fine, 50,000 pula.
Wow.
and imprisonment.
Yeah.
And imprisonment. So it's huge. It's huge.
Okay.
It's huge.
So how does constructive dismissal tie into this?
Constructive dismissal now is a form of termination of contract, section 162. So if you mistreat your employee, there's a range of options. The employee can say I was constructively dismissed without a hearing. So that will be one of the headings of the damages, unlawful termination. I had to do constructive dismissal. Then there'll be another heading for the emotional trauma at the workplace. I would have another hearing for future medical expenses, I'm sure.
This is the
this in my head.
This is at the industrial court.
Oh, yes.
Really?
And at the High Court. This is why I'm saying they're going to amend the Act. If the industrial court is going to be a division of the High Court, sort of like the Chancery Division in the UK, I'm sure that's the model they're looking for.
But, okay, so the remedies have also changed when you approach the industrial court.
Look at this as a car accident.
Dum, 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 dum.
In a car accident, there's the fine you pay to the police for negligent driving. Then there is the heading for repairing the car. That's a heading of damages. Then there's the heading for the pain and suffering. Then there's the heading for the future loss of earnings. All of those the law of delict has now met labor law in this area. Yes, that's why my face is shining. That's why I'm excited about this.
I think companies are going to need a lot of insurance.
I think companies need to change their team building exercises. A lot of team building exercises, companies, what do? They go to Mokoloji, whatever they go.
Quid pro quo
harassment.
Yes.
That's a form of sexual harassment.
Okay.
Quid pro quo harassment is where benefits are being given, promotion, less work, time off work, in exchange for favors at the boss's point of need. That's no longer allowed. You can no longer give promotions, study leave, study benefits, etc., in exchange for favors at your point of need. I'm keeping it PGA 18.
At your point of need.
Emphasis on point. Normally it's the ones with the pointy ones who want to. I think we kept the kids out. They won't know what we're talking about. There we go. So that's no longer allowed. No more quid pro quo harassment.
Yeah.
So when you're talking about sexual harassment, just to make it clear, you can discriminate based on gender. You can do quid pro quo harassment. You can offer jobs in exchange for assistance at your point of need. You can do the pay gap.
Yeah.
As part of harassment. All of these are no longer allowed. Section 18 of the Employment and Labor Relations Act. If you're an employer, you're going to read section 17, 18, 163. Please, if you've missed anything in this podcast, section 17, 18, 163, please.
Okay. So how vulnerable is an employer who doesn't have policies and training records and discipline? Yeah.
Oh my, that's very vulnerable. Very, very vulnerable. How are you going to prove that you've made your workplace safe?
Okay, so how do you prove that you've made your workplace
safe?
So
first, show your section 17 meeting, that you did have an initial meeting with your employees, you did consult with them, and call the policy something nice and sweet. You can call it workplace relations policy.
Okay.
Don't call it harassment and bullying. No one is going to read that. Safe workplace relations policy. Something progressive, progressive workplace relations policy. Give it a fancy name. So you did that. Number one, keep records of who attended the meeting. Every year, have updated training on bullying, harassment, violence, sexual harassment at the workplace. When you've got new employees, make sure they go through that as soon as possible. They go through that. Maybe have boards around your workplace, that we don't agree with this behavior. Have your policy easily accessible on your website, on your internet. Maybe make it sort of like a course. So there should be evidence that such and such an employee clicked on this slide, clicked on this, finished the online course. There's so many ways. If you're in the informal sector, at least have that record. I sat down, I spoke to my employees, I told them, no touching inappropriately, no speaking inappropriately.
This is a safe working environment.
Safe working environment. Very, very important. I don't know how Gordon Ramsay is going to do it, or people who are chefs. There's some workplaces which have got a culture of insults at the workplace. I said Gordon Ramsay loosely, but some kitchens, because I love food, I'm a foodie.
Yeah.
Some kitchens, I do hear the insults at the back. The construction industry, they do love insulting behavior. That conversation needs to happen at the workplace. And evidence, when did you meet it? When did you have that thing? That's very, very important. Employers who don't do that, super vulnerable.
This feels very character building for employers.
No, it's something, like I said, it's something welcome. Why would you want a workplace where you have huge staff turnover? One of the symptoms of a toxic work environment, the turnover is, so you're losing both good and bad employees.
Yeah, but some companies don't care, especially if you're on if you're on commission based or targets. Like if they'll give you really high targets.
I know, but I'm sure they're missing you.
Yeah, no. I mean, like in industries, let's say in retail, you get really high targets, and if you don't,
trust me, they miss their best salesperson, and they'll say, "Oh, he was a good salesperson, but he couldn't take the pressure." What they mean is, no, the workplace was toxic. You want to keep your best salesperson, make it nice, make it safe.
Yeah, no, absolutely. Are there any liabilities for directors individually?
No, it's the company and then the person who does the harassment.
Okay.
So it's either the establishment, if it's a PTY, if it's a corporate body, and then the person who does. So the person who does the harassment themselves, again, 50,000 pull a fine or imprisonment, and you're still liable to damages in delict. And then the employer, the establishment, again, you'll pay the fine and you'll still be liable in damages.
Okay.
Like I said, I can't wait to draft one of those summons.
But you hate court, or you don't hate the industrial court?
I don't mind drafting. Drafting is fun.
Oh,
I'm sure you don't mind drafting either.
I'm on a career pivot.
Okay.
You look like you are having so much fun doing what you love. I don't know if fun is the word I'd use.
Can I put in a nugget?
Yes.
I know the other nuggets we're going to get to.
Yes.
Whatever you find your hands to do it with all your might. It's a saying from King Solomon. You need to, because the only thing which you keep, which is truly real, is memories.
I understand.
It's memories. So the money you'll be paid. The money you'll always spend it, but the memories will always live with you. So do everything with all your gusto.
Is there anything the mediation process?
What about the 90 days? What about the 90 days? If you come to the Institute for Labor, we talk about how to choose between mediation and arbitration.
Okay.
The different types of disputes that are there in law.
Okay.
So we've got a dispute of right, most people don't know this. Dispute of interest, the courts don't have any jurisdiction. The industrial court has no jurisdiction over it.
Yeah.
But there's a way to get into the system, and that's arbitration. So the Act is really, really good. If you start from section 278 and you go up to 285, that talks about the Mediation Arbitration Commission, how mediation works, the powers of a mediator. They've got lots of wide powers. Most have been retained from the Trade Disputes Act. So mediators can make default awards. They hear all condonation applications. They can make advisory awards. But if you don't mediate within 30 days, that hasn't changed. Then you can either go for arbitration or you can get a certificate of failure to settle. And you go to the industrial court.
So do I only go to mediation if I've been fired?
No. If you have all types of disputes.
Okay, can you give me some examples?
One could be your chair. Maybe you don't like your chair. It's not ergonomic enough. Maybe your desk is too high or too low. Pay negotiation. So you're negotiating for a better salary. You're negotiating for better hours, for example. You don't like your deadline. So what you've just been talking about now, you believe that the workplace is toxic. Your HR is saying, no, the workplace is not toxic. You're saying, why is it toxic? No, these deadlines are not working. That's a dispute.
It feels very ideal. It sounds like you're trying to get fired.
Look, you asked me earlier how the implementation is going to work. It's only as good as the mediators and arbitrators are going to be. If they make it easy for employers to say, no, this person didn't want to work, then we're going to have a problem. We all have to...
Or victimization in the workplace afterwards.
Yes, we all have to embrace this act. We all have to have buy-in on this act. We all do. Or it's not going to work. But to answer you real quick, yes, I have seen it. I have seen employees who have had a genuine dispute. I know of one old case, a colleague of mine was doing it. So this employee was not happy because the owner of the company kept on leaving waste in his office. So you'd have parties, wild parties in his office. Your mind can go as... And in the trash can would be all the evidence, and all over the table would all the evidence of whatever wild party he was doing. And he said, I can't work in such a place anymore. That's a dispute. That's a dispute right there.
Okay.
So all types of disputes. Whether your rights are being infringed, let me break it down. So whether your rights are being infringed or you're trying to create new rights or you're trying to change the rights you have in your employment contract, those are the disputes which can be mediated.
I think I'm just remembering that most people who are able to do that or do it freely are government employees. The government employees are always suing the government for employment related.
Yes, but even in the private sector now, look, you'll always negotiate for extra pay.
Yes.
You can do that through your union.
Yeah. Okay.
These days we're sensitive about we're talking about working conditions. Yes. Why should you sit on a chair which is breaking your back?
Especially if you have a doctor's note that you have a bad back.
Why should you type like that or like that? So as we get more and more educated, we want to have... If there's one thing I hate, it's this idea that Batswana are not productive, that we are lazy. Could it be that if we improve the working conditions, you'll get to the productivity? Could it
get the best?
I think we will.
And the labor optimist in you.
Look,
yes.
I don't think Batswana are lazy. Look at this country only had 2 kilometers of tarmac road in 1966. Where did all of this come from? If we are not productive, if we are so lazy. So it's not true to generalize and say that Batswana is. It's not true.
No, absolutely. Is there anything in the Act for unions?
Oh, wow, lots.
Yeah.
Good and bad.
Yeah.
Good and bad. Now you can actually organize even before you register the Registrar of Trade Unions. You can do that. You can even approach employers. You can have meetings.
So before you couldn't, you had to be recognized before you could go canvass for members.
Yes, it was such a hustle. I worked at one place where the owner of the place wasn't happy. He was paying us late for whatever reason, and it leaked out onto social media. I believe one of the landlords of one of the workers came to ask if really they had been paid, went to Facebook and posted, and then we were all rounded up, hey, you can't say you haven't been paid, blah, 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 blah.
Yeah. Then
the unions got to hear about it. So the union said, look, we can come in, we want to recruit. They stopped the union officials from coming onto the workplace. And then we were told, like Debal, that's the honor for you, forgetting yourselves. Yeah, like Debal,
yeah.
At any time. I won't translate that. Those who hear will translate in the comments in the podcast. So now you can recruit. Now you can organize. So for 6 months you can do that. But within that 6 months, you have to register.
Yeah.
What's in it also for trade unions? Now they're going to get their dues much, much easier. From the time the employer deducts their money, it's going to come to them much, much faster than it did under the old act.
Yeah.
With an interest clause, 5% per day. For
per day.
Per day. What has the law taken?
I know unions have been struggling because government, for example, would pay really late.
Well, it's been a tough economy.
Yeah.
It's been a tough economy.
So it ripples down.
It triples down, yes. We're going to see how that goes. On the other hand, though, the act has taken away a bit from trade unions.
Yeah.
They've made it very easy for members to get out of trade unions, which is a scary thing.
Yeah.
For those of us in the labor sphere, because trade unions, if you look at the history of it, they started off on the left. Marxism, socialism, that was the thinking. That's a whole other lecture and discussion. But now, Max, trade unions are becoming more and more capitalist. A lot of trade unions are doing businesses, are giving out loans, funeral schemes, laptop schemes, cell phone schemes, things like that. By making it easier for employees to leave a trade union within 1 month, trade unions potentially are going to be having the burden of someone who has left. They haven't paid off their dues, but they've given their notice of leaving. So you asked about implementation. We want to see how that's going to work.
Yeah.
It's going to be very, very interesting. I don't know if that's going to work very, very well. And then this is another podcast also.
Yeah.
For you to be recognized by the employer, there's a new requirement in section 245, subsection 4, called sufficient representation. There's steps A up to H actually, of things a trade union should show to demonstrate that they're sufficiently representative. That also comes from our constitution. Whether or not unions understand the burden which is on them, whether they're going to meet it year after year after year, we'll have to see once the act comes into play.
Okay. So you were part of the reform of the labor.
Well, the
law.
institute
was part of it.
Was given by the time I joined in 2022.
Okay.
This act has been in the works from around, let's say, 2015, the federations make complaints to the ILO. 2015. By 2019, there actually was a second draft.
Yeah.
And then, of course, COVID comes in. But by 2019, there actually was a second draft of the new Employment and Labor Relations Act. So this has been in the works. It had interesting leave provisions like surrogacy leave.
Oh, okay.
One of the drafts, yes.
Okay.
There was discussions around menstrual leave. Can we say that on this podcast?
Yes.
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 Yeah. Menstrual leave was supposed to be there. Longer maternity leave, 100%. So and the tripartite was involved. This was government, Business Botswana, and the two federations.
Okay.
Those are the three big. That was the committee.
The big stakeholders.
Those are the big stakeholders. That were
How was the tug of war? How was the tug?
I can say this now. This is an open secret. The business community is not particularly excited about the act because there's going to be a lot of adjustment from their side. There's a lot of fear that employees will start exploiting all of these leaves and stuff. But we're in a recession right now. Employees want to keep their jobs. So the pessimism from business, I think, is misconceived. I think they'll still make profit. I think so long as they comply with the provisions, they might not even feel much change. We might actually see less trade unions. I think the trade unions which are there on paper are going to be sifted away. I really look forward to better labor relations and more productivity.
So there's no need for...
There's no need for fear. There's no need for If you're a good employer, there should be no need for fear. I'm more scared for you and me as employers.
I think we'll go and read and inform ourselves so we don't get in trouble.
Please.
Not fire people without notice.
I don't want you and me to be the only ones who are really excited about this act. We need to get...
Yeah, because the penalties are not... They're hefty.
50,000, 3 years employment. Most of the penalties, 50,000, 3 years employment. 50,
imprisonment.
Imprisonment, yes. And I hate jail because... Like I said earlier, I'm heterosexual.
Okay, so which policies are absolutely necessary?
Oh, of course, the violence, bullying, and harassment.
Okay.
That's necessary. Your leave provisions. We didn't speak about annual leave in depth. So now, leave encashment. Hello?
Yeah?
Leave encashment is something.
It's new.
There are certain things you have to fulfill. If you're an employer, go to section 218.
Oh, yes, annual leave. Oh, that if you're not allowed to go on annual leave.
Yes, there you go. So you want to change your policy on annual leave. For those who don't have family responsibility, what they call compassionate, you want to change all of that so that
the language.
You change the language. Your policy on overtime, shift work, night work, make sure you're giving people overtime. Make sure that they're not working more than 14 hours of overtime per month. Otherwise, now you're doing harassment. Now you're doing bullying. If you're giving them night work, make sure you're taking them to work, you're bringing them back. You've offered them day work. Keep that record of that. Have a grievance procedure. Let the employees know that if they have a complaint, who can they speak to, and at what stage is it going to labor? That one they should know, absolutely. If you don't have that, you've got a toxic work environment. You're falling back to Section 17 and 18. Those policies need to change.
And you can help with those policies.
I can help. The institution can help. You know.
Oh, actually, so what happens if my employer refuses me to take annual leave?
Refuses. Okay.
Or makes it difficult?
Two things. So we highly encourage that you should have a leave plan.
Okay.
At the beginning of a leave cycle, employer and employee have a leave plan.
Is there anything in the Act?
Talk about leave plan.
About annual leave and if they refuse?
Yeah, there's Section 218. So you should have, it says leave should be by agreement, or if there's no agreement, then at a time determined by the employer. And then there are these magical words: an employer shall not refuse leave. What an employer can do is say, no, this day is not convenient. Okay, and then they offer another one. That record should be there. Now, if it accrues for a maximum of 3 years, annual leave entitlement, then the Act says that an employee will be paid in monies. Glory to God. Not 100%.
Yeah.
I'm sure what the percentage.
But at least it will also it will encourage employers to encourage employees to rest.
Yes, a well-rested employee is a productive employee.
Yeah.
And employers will say, no, the Act is favoring, you're giving leave anyway, so don't be too scared.
I actually just remembered something. There's also a provision about sick leave that if you fall ill during annual leave, you can convert it to sick leave.
Yes.
Yeah.
When you're on annual, you're a good student.
You're taking notes.
Yes. Please, but preach.
Yes,
preach.
absolutely.
Yes.
I really love sharing information. So what's the biggest mindset shift that employers and employees should have towards this Act?
I call it let us work together. Let us be productive together.
Yeah.
Let's stop antagonizing each other. If I'm not working well, try and find out why I'm not working well. Let's move together towards the goal of developing our nation of Botswana. That's the main mind shift. It's not them, no longer they and them. We all have a common goal, and that's productivity. If the employer wins, the employee wins. That's the big idea.
We are almost at the end of our conversation, and the time just flies, right?
What is the time?
Okay, so you say win with humility, lose with honor. What does that mean in practice?
Something I live by.
Yeah.
I really hate arrogant people, and I try to, I'm not saying I'm perfect, I try my best to remove. So whenever you win, be humble about it. And the team I support, the football team I win, I support them because when we do win, we remain humble. We're the most humble fans.
Really? That sounds very unlikely for football.
When you lose with honor. How do you get that honor? If you've put in your best, but you still lose, then you've lost with honor and dignity. You shouldn't lose, and the reason why you've lost is because you didn't try hard enough. You didn't put in your best. My team also does that, even in our losses.
Yeah.
Yes, you can say no, but
yeah.
You can see it.
Okay.
So that's a mantra I live my life by.
Okay.
You should try it.
Yes,
Win
absolutely.
Lose with honor.
Absolutely.
If ever you come back to practice, the same. The judge should say that, counsel, I loved your heads, well researched. However,
yeah, absolutely.
Yes.
You also say, breathe, you're not drowning.
Yes. None of your greatest fears. Think about it. Okay, this is why I said earlier I don't believe in therapy, but this is my own self-therapy.
This is you giving us therapy.
Oh, okay, there we go.
Yeah.
So, anytime you're worried, anytime you're really, really scared, close your eyes. Think about the worst fear you ever had. I'm willing to bet 80% it didn't come true. Your worst fear didn't come true. So when you're going through life storms, just keep calm and remind yourself, look, if you're still breathing, if it hasn't killed you yet, you're not drowning. Just breathe. The way out is going to come. The answer is going to come.
You sound like you give really good pep talks.
And I hope,
jolting.
of course, it's easier said than done. When I'm in the fire, you should
No,
see
absolutely.
me.
No, but I think it's... and then leadership lessons from Jürgen Klopp.
Yes, Jürgen Klopp is the coach of my team.
Oh my goodness, I walked right into this, didn't I?
No.
Oh yes, but please do share.
He's a great leader. And because we're about employment and labor relations, he's an example of how this act should be.
Okay.
So he would hug his players. He wouldn't give destructive criticism. It was always constructive criticism. He was a winner. His win was the team's win. And Jürgen Klopp is a true leader. And he never gave up. When he came and joined us, he lost his first 4 finals with us. But he kept on telling the boys, there will be another final. Letting go of the past, reaching for ahead. In the end, he won the Premier League. He won the Champions League. He had lost in Europe, but he did bring that success and brought the team back to where it was. So learn from Jürgen Klopp. Try and be a leader by example. He's now the coach of the German national team. Germany is going through, you saw them at the World Cup. Watch them at the next tournament. That's all I'm going to say.
What do you want to be remembered for?
I hope I'm remembered as a great dad. I hope I'm remembered as a good lecturer. I hope I'm remembered as someone who put a difference in Botswana. I'm hoping to meet one of my students somewhere.
Yeah.
In some sphere and doing good. And in my small way, I'm remembered as one of the guys who spoke for change in the workplace in Botswana, because I'm really sad that we didn't do well in the happiness index. And I've had so many happy moments in Botswana.
Yeah.
In fact, I've been happiest here. I'm happiest in Botswana. So I wonder why we failed. Maybe we're too honest. Maybe other countries lied. Or maybe we need to change the one place where we are sad, which is the workplace. So I hope that changes.
Wow, what a beautiful ending. I need to have a slow clap, like a standing ovation.
I'm a yellow bonnet.
I love that so much. Okay, thank you so much for this interview. It was quite enlightening.
I've finished my water. You haven't finished yours.
Yeah. I've had a lot of water today. Okay, so please tell us about Iles. Tell us about what you do, where we can find you, what services you offer.
Institute for Labor and Employment Studies.
You can look into your favorite
African
camera.
Mall, plot 931. Of course, you've heard about research into labor matters. If your union is thinking of going to negotiate, we prepare wonderful position papers. We also offer professional services like chairing of disciplinary hearings. We can rewrite your policies, stuff like that. We do lots of trainings. We've got a diploma in labor law. Everything we've been talking about is part of a 2-year program where in a more painless method, we teach you all of these things. We also have facility hire. You can come and hire our boardroom. It's an executive boardroom. You can have secret meetings. No one will know you're in African Mall, and you can do that there. So that's what we do at the Institute for Labor and Employment Studies. Thank you.
Oh, you speak so well.
I hope so.
Thank you so much for your time. Thank you for sharing. You normally charge for this and you charge for trainings, but thank you for honoring us today. And
thank you for, like I said, opportunity of a lifetime must be taken in the lifetime of the opportunity. So this was an opportunity of a lifetime. Like I said, this was the first time I came for a podcast. I've done 2 more since I've been here.
Oh, really?
So this is where I broke my virginity, podcast virginity. So I always go to off-script Africa.
Yes.
Thank
you so much for honoring us again. And being such a good sport and, just coming back.
No, thank you guys for seeing me and giving me this platform. It's really an honor. It really, really is.
Okay. And there we have it. That was our episode with David Mujama. I hope that you learned a lot. I hope you're going to go and change your policies. I hope that with the implementation of the new labor law, you'll give Iles a call, go for training, train your employees, and let's have a better Botswana. I'm your host, Amo. Thank you so much for joining us. Please don't forget to like, share, and subscribe. Engage with our content so we can bring you more of this. Off Script Africa. Cheers!
Cheers!